Good day, and today I will be going to discuss the lessons that we have encountered during our midterm and the subject of CLG5 evidence while being blindfolded. But before that, let me introduce myself first. I am Michael Justimbaste Remedios, Block 2, third year criminology student. So without further ado, let us begin. So the first topic that we will be discussing is about judicial notice. So first, what is judicial notice? So judicial notice is when the court accepts certain facts without needing a proof or an evidence because it is a common knowledge. So for example, Mr. Rodrigo Roa Duterte is our late president or our ex-president. So the court will not needing any evidence or proof because it is a common knowledge. And also, judicial notice helps to speed up the process by skipping over the facts that don't need to be argued. So next is judicial notice when mandatory. So judicial notice is mandatory when a fact is widely known or can be easily verified, like a law or historical facts, and doesn't need any evidence to prove it. So here is the list down of the facts that doesn't need a proof or evidence. And next is judicial notice when discretionary. But before that, let me first define what is discretionary. Discretionary means having a freedom or a power to make decisions or choices based on judgment. So judicial notice is discretionary when the court decides whether to accept a fact that is not widely known or easily verifiable, like specific local facts or certain scientific knowledge. Judicial notice when discretionary if first it is a public knowledge. So for judicial notice, when the court chooses to accept a widely known fact, for example, a recent widely reported news, just like our issue with regards to our ex-president, wherein he is being arrested and rid of his rights. Second is if it's capable of unquestionable demonstration, meaning to say something that can be proved beyond reasonable doubt with clear and indispensable evidence. And then lastly is ought to be known to judges because of their judicial functions. For example, judges should know the basic laws of their jurisdiction, like the right to fair trial, meaning to say the laws that judges are expected to be familiar with due to their role or and and experience. Next is judicial notice when hearing is necessary. So hearing is necessary for judicial notice when a party requests and it provides sufficient information. So for example, in a trial, a lawyer asks the judge to recognize that a certain law exists. The judge hold a brief hearing to review the law's detail before accepting it as a true. So, so next is the admission and confession. So what is admission? Admission refers to a person acknowledges or accepts certain facts, like being at the scene of the crime without necessarily admitting the guilt. While on the other hand, confession is when a person admits to committing a crime and it can be used as evidence in court. So for example, in confession, the suspect confess help to solve a case, while on the other hand, the example for admission is the defendant's admission of being at the crime scene was used in the investigation. So the main difference between these two terms is that the admission is the acknowledges of or admitting certain facts with justification or simplification. And while confession is admitting without any justification or exemplification. So next is we will be going to be discuss the judicial admission. It is when a party in a legal case formally acknowledges a fact during the court proceedings, which can be used as evidence without needing further proof. So next, we will going to discuss the Latin maxim res inter alios acta alter in sere non debet, meaning to say the things done between strangers ought not to injure those who are not parties to them. So it has two branches, the admission by third parties, and the second one is the similar acts of evidence. First is we have the admission by a co-partner. So it denotes to a statement made by one partner in a partnership. So meaning to say they both have a relationship or a partnership, which can be used as evidence against the partnership or other partners in a legal case. So for example, one partner's admissions about their involvement in illegal activities or in illegal activities could affect the entire business. So the second is the admission by a conspirator. So it refers to a statement made by a person involved in conspiracy, meaning to say they have an agreement, which can be used as evidence against them or others involved in the conspiracy or an agreement. So example, one conspirator's admission of planning the crime helped to prove the group's involvement. So lastly is the admission by previs. So it refers to a statement made by a person who has a legal connection or relationship with another parties. So for example, the admission by a deceased person's family uh, about the deceased actions could be used in a related legal case. So the second branch of the res inter alios acta altere nocere non debet is the similar act as evidence. So it refers to using of a person's past action or behavior in similar situations to show a pattern or an intent in a current case. So for example, in a case of a theft, evidence of previous theft records or committed by the defendant could be used to show a pattern of his behavior. Next is the implied admission. Under this, we have the admission by silence, or also known as the adaptive admission. It is wherein silence is occur when a person fails to deny or respond to an accusations or a statement, no? And their silence is interpreted as an acknowledgement of the truth of that statement. So for example, in a conversation, if someone is accused of stealing, let's just say accused of stealing and remains silent, so it can be interpreted that their silence is may be seen as an admission. Judicial confession. So a judicial confession is a formal admission made by a person in a court, no? It is a confession made inside a court or in the front of a judge, acknowledging their guilt in committing a crime. So for example, the defendant's judicial confessions during trial lead to a quicker conviction, no? Lead to a quicker conviction because he made a confession while on trial inside the court and in front also of a judge. So how about extrajudicial confession? So it is also an admission, but it is made outside the court, such as the police or in a private setting. It can be used as evidence if it was made voluntarily, and also it has been made in writing. So, for example, the suspect's extrajudicial confession to the police help in solving the case. No? Lastly, in our topic for confession and admissions, we have interlocking confessions. So, wherein multiple individuals involved in a crime each make separate confessions and their statements are aligned or supported to each other, helping to establish the truth of the crime. So, for example, the confession of two conspirators were wherein interlocking, matching each other's detail about the crime they committed. So after that, we will now proceed to the three general forms of evidence. So we have the object evidence, the documentary evidence, and the testimonial evidence. So first, we will be discuss the object evidence. So object evidence refers to a physical items or objects that are presented in a court to prove fact or support a case or a criminal case. For example, the weapon used in robbery is the object evidence presented in the court. And also it is addresses to the senses of the court, no, ang object evidence. So the second general form of evidence is called the documentary evidence, no. So it refers to any written or printed material used in court to support or claim or even to prove a fact, such as contracts, letters, or even records. Now, let us discuss the original document rule. No, it states that in legal proceedings, the original version of the document is required as evidence, not copies unless there is a valid reason the original cannot be provided. For example, if the original is broken or damaged, no, or even lost. So, for example, if a contract is being used in a court, the original signed contract must be presented, not just a photocopy, unless the original is lost or destroyed. So lastly is the third general form of evidence, which is the testimonial evidence. No, as defined, it is an information provided by a witness under oath, no, during a trial, typically in a form of a spoken words, no, or spoken words, no. So for example, if someone saw an accident happen, no, their spoken testimony or their statement in a court about what they witnessed would be considered as testimonial evidence. So that's it. I hope you like the discussions I made while being blindfolded. So thank you, and thank you for listening.